At a just concluded African Union summit in Addis Ababa, African leaders agreed to form an African court, arguing that the ICC is an imperialist court. While that argument has sparked a major debate among Africans, one British scholar agrees with the AU. Asha Mwilu reports.
Maintain our resolve towards ensuring adequate.
The African leaders resolved to abandon the International Criminal Court and form an African court may have elicited diverse opinions from Africans, but the AU's move has received a boost from an unlikely source.
The claim to be truly international is not really based on the evidence.
British author David Hoyle released his book titled Justice Denied, terming the ICC as a racist court.
Within the founding statute of the International Criminal Court, the Rome Statute, agreed in 1998, 2 articles give the United Nations Security Council special prosecutorial rights. Now the irony is that 3 of the 5 permanent members of the UN Security Council, the United States, China and Russia, are not members of the ICC.
But as David pokes holes into the International Criminal Court, Professor Atuoli Lukoye thinks that by signing the Rome Statute, African leaders made their bed and must lay on it.
Same people who were in government and in opposition at the time and who supported the ICC are still around in government and in opposition. And these cases, when they were taken to the ICC, again it was with full cooperation of the then government and opposition, and up to now they are still around.
We tried as much as we could with President Kibaki to create a local mechanism to deal with our cases. We tried as hard to persuade our members of parliament to pass a law that would have enabled us to set up a local tribunal.
Part of the newly released book is this argument that the ICC is controlled by its funders.
He who pays the musician, he who pays the piper, will call the tune. 2/3 of the funding for the International Criminal Court comes from Europe, and specifically the European Union member states. So it serves in effect as a de facto servant of the people who fund it.
An argument that appeared to inform the AU's decision to opt for an African court.
Kenya today pledges $1 million to the establishment of the African Court of Justice and Human Rights. I urge you, brothers and sisters, to join me in ensuring that the necessary ratifications are in place and the resulting court is fully owned, financed and driven by Africa.
There are failures that have been mentioned, including what we hear now, that the ICC is being presented as a court of the West against poor African countries and so on and so forth. But those are not subjects that can be fully exhausted or discussed at this point in time, being in the thick of action with ICC.
I don't think that it is really right to go and purport to be speaking on behalf of the people of Kenya without asking the people of Kenya.
And while the president's lobbying for a more local court could not be divorced from the strategy to have William Ruto's case at the ICC dropped, could the opposition leader be warming up as a defense witness for Ruto?
If I am asked to testify, I am willing and ready to testify on behalf of my party, the Orange Democratic Movement. But so far, I have not been requested.
In response, Deputy President William Ruto sent a statement to the newsrooms saying that he welcomes Raila's offer to testify. Ruto, however, says that his conscience remains clear, adding that he believes that he will soon be vindicated as his legal team handles his case on issues of evidence. And as African leaders juggle between the fight for independence and the allegations of impunity, it still remains to be seen whether the AU will successfully advocate for the referral of the pending African cases back to the continent. Asha Mwilu, KTN.